3 out of 4 people who told a debt collector to stop calling said the calls kept coming anyway. Same number on the screen, same time of day, the phone buzzing on the counter while they're trying to eat dinner or get the kids down, or just sit for 10 minutes without their stomach dropping. And most of them did the one thing that feels right and changes almost nothing. They picked up and they said it out loud. Please stop. But there's a line in federal law that can force a debt collector to actually stop. Not slow down, stop. And it doesn't care how upset you are when you say it or how nicely you ask. It cares about one thing, one specific thing that most people never do. The ones who do it, a lot of them never hear from that debt collector again. Some of them walk away with money the collector had to pay them. The calls, the pleading, the "I already told you I can't pay," the law barely touches any of it. So what's the difference between the version that works and the version that doesn't? For most people, it starts with a number they don't recognize, an unfamiliar area code 3 or 4 times a day, and then a voice that knows your name and how much you supposedly owe. And the first instinct, the human one, is to explain yourself. You pick up, you say you lost your job, or the bill's wrong, or you just need a little time. You're reasonable, you're polite, and none of it counts for much, because the law that protects you here doesn't run on conversations. It runs on paper. There's a federal law from 1978. People call it the Fair Debt Collection Practices Act, but the name doesn't matter. What matters is what's buried in one part of it. It says if you tell a debt collector in writing that you want them to stop contacting you, they have to stop. That's it. Not negotiate, not slow down to once a week. Stop. After that, they're allowed to reach out one more time, basically just to say, okay, we're done, or fine, we may sue you. And then they have to go quiet. In writing. Those 2 words are the whole game. Because here's what the law does and doesn't care about. You can call the collector 40 times. You can cry on the phone. You can scream that you already told them 6 times to leave you alone. The federal cease all protection doesn't fully kick in from any of that. It kicks in when you put it in writing and they receive it. There's a softer version that does work out loud, and it's worth knowing because it's where people get tripped up. Under the newer rules, these came in at the end of 2021, if you tell a collector, stop calling me, they have to stop calling, but only calling. Read that twice because I had to. You say, stop calling, and they can turn right around and text you, email you. The spoken word only shuts the door you named. It leaves every other door open. So the person who says, quit calling, and feels like they handled it, 3 days later, there's a text, and they think the collector broke the law, when really the collector just walked through the door that was still unlocked. The written letter is different. The written letter shuts every door at once. And the cost of not knowing this gap is bigger than annoyance. The government's own numbers tell the story. In 2024, people filed about 207,800 complaints about debt collectors. That's nearly double the year before. The single most common complaint, year after year since they started tracking it back in 2013, isn't rudeness or too many calls. It's people saying the debt isn't even theirs. Almost half of those complaints, 45%, were somebody saying, I don't owe this. Sit with that for a second. Nearly half. The phone's ringing off the hook over money the person on the other end may not actually owe. A bill that got paid, a medical charge insurance should have covered. Sometimes a debt that belongs to a stranger with a similar name, sold off for pennies and chased anyway. So when people say, just ignore it, it'll go away, I don't agree with that, and I'll tell you why in a minute, because ignoring it is its own kind of trap. But I understand the instinct. When the calls are about something you're not even sure is real, picking up feels like volunteering for an argument you can't win. Now here's the part that should make you a little angry. Remember those people who did speak up? Over 40% of folks who got contacted about a debt told the collector to knock it off. They did the brave thing. And 3 out of 4 of them said the calls just kept coming. Same number, same dinner hour, like they never said a word. Some of that is collectors ignoring a spoken request they were technically supposed to honor. Some of it is people saying stop calling and getting a text instead, then more calls on a different account. But a lot of it comes down to this. A phone call leaves no proof. You said it, they say you didn't. There's no record, no date, nothing to wave in front of a judge. The letter leaves a footprint. The phone call leaves nothing but your word against theirs. And there's one more thing the calls are quietly counting on you not to know. This whole protection, the "you have to stop" part, it only applies to a certain kind of company, not everyone who calls about money. The law is aimed at debt collectors, the collection agencies, the companies that buy up old debt for cheap and chase it, the lawyers who collect for a living. It generally does not cover the original company you owed in the first place. Your own credit card company, calling about your own credit card, collecting its own debt, usually isn't bound by this federal law at all. Same words out of your mouth, same letter in the mail, and the protection can just not apply depending on who's actually calling. I know, it sounds backwards. The faceless agency that bought your debt for 4 cents on the dollar has to stop when you tell them to, but the bank you actually borrowed from might not. That's the federal floor, and it's full of holes, and a few states have spent years trying to patch them, which raises the question nobody asks until they're standing in it, phone buzzing on the counter for the 5th time that day. Okay, so what is this letter exactly? What has to be in it? And if I send it, and the calls stop, does that mean the debt is gone too? That last one is where most people get it badly, expensively wrong, because stopping the calls and clearing the debt are two different things, and the law lets you do the first without touching the second. That's the part that costs people. They send the letter, the phone finally goes quiet, and they exhale like it's over. It's not over. The debt's still sitting there, the clock on it's still running, and the thing they just did, going silent, can quietly turn into the worst move available because the next sound after the call stop isn't always silence. Sometimes it's a court summons. So let's talk about the letter itself, because it's almost insultingly simple, and that simplicity is exactly why people don't trust it. There's no magic wording, no legal phrases you have to get right. You write down that you want the collector to stop contacting you or that you refuse to pay, you put your name on it, and you send it to the collector. That's the whole thing. People generally keep a copy, and they send it in a way that proves it landed, certified mail, the kind where someone signs for it, because the law treats your request as official the moment they receive it. No signature, no proof of receipt, and you're back to your word against theirs. The free version exists, by the way. The Federal Consumer Agency, the CFPB, publishes sample letters you can just use. One of them is the Stop Contacting Me letter. You don't pay anyone. Now, I'll be honest about something most channels won't mention. That agency is going through a rough stretch right now. Funding fights, the whole thing's been in question through 2026. So if you go looking for that tool and the website's acting strange, that's why. The letters in the law still work. The agency that hands them out is just on a shakier ground than it used to be. Here's where I split from the usual advice. A lot of people online treat that complaint button, file a complaint with the CFPB, like it's the move. Push the button and the cavalry comes. I wouldn't lean on that anymore, and not because complaints are useless, it's because the federal cavalry mostly isn't writing right now. In all of 2024, that agency brought 0 enforcement actions under this debt collection law. 0. The complaint still creates a record, which has its uses, but if you're picturing a federal officer calling your collector and reading them the Riot Act, that's not the world we're in at the moment. So what actually has teeth? You do. You, personally, in court. This is the part almost nobody knows, and it's the real answer to why some people walk away with money. If a collector breaks this law, keeps calling you after you sent that letter, calls you 20 times in a week, lies about what you owe, you can sue them, and you don't have to prove the calls cost you a dime. The law lets you collect up to $1,000 just for the violation itself, plus your actual losses if you had any, and this is the part that changes everything. Your lawyer's fees come out of the collector's pocket, not yours. Read that again, because it's the whole reason this isn't hopeless. The collector pays your lawyer, which means there are attorneys who'll take these cases for nothing up front, because they get paid by the other side when they win. The Supreme Court did put a hard fence around it, though. You have 1 year from the violation to file. 1 year. Miss it, and the strongest case in the world is worth nothing. So the people who sit on it for 18 months because they were embarrassed or busy or hoping it'd resolve itself, they let the one tool with real teeth rust out. And then there's where you live, which can change everything. The federal law is the floor. Some states built something much stronger on top of it. In California, the state version reaches the original creditor too, your own bank, your own card company, and closes that hole I told you about. Massachusetts caps collectors at 2 calls a week, not the federal 7. New York City just tightened its rules even further. If you're in one of those places, you've got more power than the federal law alone would suggest, and most people never find out because they only ever hear about the federal version. Here's the obstacle nobody warns you about, the human one. You'll send the letter, and for a few days, nothing. And that quiet is uncomfortable in its own way, because now you're waiting. Did it land? Did they get it? Is this actually working? Then maybe one more contact comes, the legal one, the "we may take further action," and your stomach drops all over again. That's allowed. That's the law working, not breaking. And if real calls keep coming after that, the letter you kept, the one with the certified mail receipt stapled to it, stops being a piece of paper and becomes evidence. This is also the point where I tell my own parent, stop reading the internet. If a collector is still calling after you did everything right, or if there's a lawsuit, or if the money is real and large, that's not a 15-minute video problem anymore. That's a sit down with a lawyer in your state problem. And because of that fees paid rule, it may cost you a lot less than you're afraid it will. A free consult with a consumer attorney is a phone call, not a fortune. I keep coming back to the quiet after the calls stop. That's the dangerous part. Not the ringing. People survive the ringing. It's the silence that feels like an ending when it's really just a pause. The debt still sitting in a folder somewhere with your name on it. The clock still ticking. The summons that may or may not come. The phone's been buzzing on that counter for weeks. You finally have the one thing that makes it stop. And the strange truth is making it stop was never the hard part. Knowing what the silence actually means, that's the part nobody teaches you until you're already standing in it. It means the debt didn't die. It just went quiet, same as the phone. And the debt that's gone quiet still has 2 things running in the background, and both of them are traps people walk straight into without ever seeing the edge. The first one is the move almost nobody tells you to make, even though it might be the strongest one you've got, especially when you remember that nearly half of the people getting these calls say they don't even owe the money. You can make them prove it. The law gives you a window, about 30 days from the first time a collector contacts you, to write back and say, in plain terms, show me this is real. And when you do that, they're not allowed to keep collecting until they actually verify it. They have to stop and go find the paperwork, the original account, the real amount, proof it's yours, and proof they have the right to chase it. Why does that matter so much? Because a lot of old debt gets bought and sold so many times that by the time it reaches the company calling you, what they actually own is a name, a phone number, and a dollar figure on a spreadsheet. Sometimes that's the whole file. So when somebody writes back and says, prove it, a real chunk of the time the proof never shows up. Not because anyone forced them to quit, because there was never anything solid under the calls to begin with. The obstacle here is sneaky. They'll often mail you something that looks official, a printout, a statement with your name across the top, and act like that closes the matter. It might not. A page they typed up is not the same as the actual account records. People see a logo and assume they've been answered. A lot of the time, they haven't. The second trap is the one that genuinely worries me because it's wearing a disguise. It looks like the responsible thing to do. Old debt doesn't last forever. Every state has a time limit, usually a few years, after which a collector can't actually take you to court to force you to pay. The debt still technically exists, they can still ask, but they've lost their biggest weapon, the courtroom. A debt past that line is, for all practical purposes, a debt that can't be squeezed out of you. And here's the cruel mechanics of it. You can wake that dead debt back up. In a lot of places, if you make even a small payment on a very old debt, or you sign something saying it's yours, or you just tell them, okay, I'll start paying, the clock can reset all the way to 0. The thing that felt like good faith, the $20 you sent to show you're trying, can hand the collector back the exact weapon the calendar had already taken away. Sit with how backwards that is. The person who ignores the ancient debt completely is sometimes safer than the person who tries to do a little bit of the right thing. I'm not telling you to stiff anybody. I'm telling you that on a debt that old, a payment isn't really a payment. It's closer to a signature on a contract you didn't know you were signing. And the collector calling about a debt that's almost too old to sue on, they know precisely where that line sits. You usually don't, which is why, under all of this, the boring thing turns out to be the thing that saves people. The ones who come through it in one piece almost always kept a record. the letter they sent, the day it landed, the date and time of every call that came after they sent it. People hate this part. It feels small. It feels like filing while your stomach's in a knot. And plenty of them throw the envelopes out because looking at them hurts. But that shoebox of dates is the whole difference between they harassed me and being able to show on paper exactly when and exactly how many times. One of those wins cases. The other is just a feeling. And if the calls keep coming after you did everything right, after the letter, after they signed for it, that's not the end of the road. That's where the law finally bites, and you already heard how that part works. Somebody walking into a free consultation with a consumer attorney holding clean records is in a completely different position than somebody carrying nothing but anger and a fuzzy memory of a lot of calls. That's the move I'd push hardest on, the one I'd lean on my own parent about. Not the complaint button, the records, because the records are what make every other option real. I'll be straight about the limit, the same way I'd want it given to me. None of this is a magic word that makes a debt you actually owe vanish. If the money's real and it's yours, the calls going quiet doesn't erase it, and pretending otherwise is how people get blindsided in a courtroom. What all of this really is, the letter, the prove-it window, the clock, the shoebox, is the difference between being someone things just happen to and being someone who knows the rules of the room they got dragged into. So picture that counter one more time. The phone is quiet now. There's a folder sitting there, maybe an envelope you've been avoiding, maybe a letter you finally sent with a little green card stapled to it, proof they signed. For weeks, the loudest thing in the house was the ringing. Now the loudest thing is the choice. The $20 you almost sent that you now know to hold on to. The 30-day window you didn't know was a window. The records you nearly dropped in the trash. Nobody hands you any of this. Not the collector, not the company that sold your debt for pennies. You find it the way almost everyone finds it. Late, a little scared, already standing in the middle of it. I just wish somebody told you before the phone ever rang.